We have Mr. Alejo here.
Mr. Alejo is not here.
Okay, I should bench one for Alejo. Okay, on the record in the matter of the people of the state of Michigan versus Marion Dunwoody Moore, file number 23-00839. Appearance, please.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Okay, I see Mr. Dunwoody Moore is present in person at the court. Do you have an attorney?
No, ma'am.
Okay, I see you pled not guilty at your arraignment and requested court-appointed counsel. What happened?
My phone was off at the moment when they tried to contact me and I couldn't answer the phone call.
Okay, did you meet with them today?
Yes, ma'am.
Okay,
Mr. Dinwiddie Moore has made arrangements with his PO, and I believe that the probation officer has been in contact with the prosecutor and that these charges are going to be dismissed. Therefore, I don't think it would really be necessary for us to be assigned, but we're still at the court make that determination.
And I was just pulling up his file. His probation.
okay, one moment. I just seen an email, so it said they have to request dismissal. They can't dismiss it after they issue it. Okay, I do have an email today from your probation officer. So these will dismiss the violations. You're all set.
Thank you.
On the record in the matter of the people of the state of Michigan versus Tama Abtalem. Present. Okay, thank you, Warrant. What's your name, sir?
Alex, here.
On the record in the matter of the people of the state of Michigan versus Alex Harris, file number 23-02328, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Luke Goodrich from the Public Defender's Office here to represent Mr. Harris, who's standing to my right.
Okay, today the state is set for a competency. What? Here. Okay, so for competency, but I don't think I reviewed it before. Or while I was gone. Okay, I have a report that's dated for January 16, 2024 from the state of Michigan Department for Health and Human Services Center for Forensic Psychiatry. Counsel, did you get a copy of that report?
Yes, Your Honor.
Yes, sir.
Okay, the report opines that the defendant has been deemed incompetent to stand trial and not likely to attain competence if provided a course of treatment within the time limit established by section 1034. Is there any reason to object to the body of the report or the findings?
No, Your Honor. No objections.
No objections from the defense, Your Honor.
Okay, without objection, the court will adopt the findings of the report and enter an order deeming the defendant to be incompetent to stand trial. I'll incorporate the report into the file we'll set this matter for a further proceeding so that the prosecutor's office and the defense counsel will determine how they want to move forward on this. Let's do a, like, I guess we'll call it a free trial. We can do February 15th and 9:30. February 15th at 9:30 will be the next court date. Any additional matters for today's record?
Nothing for the people, Your Honor.
Your Honor, I prepared a finding and order and competency, but is that what you wanted to address at the next hearing on the 15th, essentially?
Well, let me see what you have there. Okay, let's see here. I'll sign this, and the prosecuting attorney still needs to take some efforts after this to make sure the case is properly disposed of. And so we'll set this a pretrial date that's more or less a review date to make sure we don't, the case doesn't fall through the cracks. And so again, the order of competency or finding of incompetency has been signed and dated for today. Any additional matters for today's record?
Nothing for the people.
No, Your Honor.
Thank you. You're all set. Thank you. Record in the matter of the people of the state of Michigan versus Jessica May Hahn, file number 18-02423. Jessica Hahn present. Sure, bench warrant. Mr. Hayes here. Which matter is he here for? On the record in the matter of the people of the state of Michigan versus Rodrigo Quintana, file number 23-01122. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
What's your name, sir?
Rodrigo Quintana.
Okay, you requested court appointed counsel.
This would be another instance where the probation officer had made our office aware that they would be asking for dismissal of the violations due to Mr. Quintana's compliance with probation.
Who's his probation officer?
That was
Bayless.
yes.
I don't see an email. Let's see. I don't have any communication from Ms. Bayless.
I believe it was sent to Ms. Nash and Mr. Whitman, but I can forward it to you as well.
And Mr. Lee's in custody. Yes, please. That's probably who Mr. Hayes is. I don't have any emails. You have any? Yeah, for other people.
Sorry, I forwarded you, my Wi-Fi's been really bad today, so.
Yeah, I don't have anything yet. Okay, well.
My apologies,
They provide, I received Ms. Nash forwarded the email. I have an email indicating that he did make a payment on the balance, that he's enrolled in outpatient and they're supporting documents on January 30th. Oh, no, he enrolled on January 9th. Made payments January 9th, enrolled on January 17th at Crystal Ray for outpatient. DV enrollment was January 5th, and then Crystal Ray parenting class on December 18th. There's still the violation that he failed to appear for monthly meetings and that he absconded.
That's correct, Your Honor. So the people would be moving to dismiss the violations number 6, 18, 19, and 20, and we would be continuing to pursue violation number 3.
Violation number 3 is still pending, and he requested court appointed counsel.
I talked to someone and I had
An attorney?
Yes.
Which attorney did you talk to?
I don't remember the name.
Can I have your appearance for the records, please?
Yes. Assistant Public Defender John Lee.
There's still a violation that's pending, even with the email that I sent. There's a violation he was arraigned for, that he failed to appear for his probation meeting since October, well, really since September, and that he absconded. I'm not dismissing that. There wasn't even a request for me to dismiss that.
Yes, Your Honor, I, just for the record, when I spoke with Mr. Quintana, the discussion him and I had was not, our assistance was not dependent upon his cases being dismissed. He had a plan to deal with any remaining violations and said he wanted to proceed on his own.
Without counsel, so you don't want counsel?
But if he wants it now,
Yeah.
of course, we're here, yes.
Okay, do you need time to speak to them privately?
Yeah.
It doesn't sound like you know what you want to do. Well, you can have a seat. We'll call your case again and you'll have opportunity to speak with counsel privately, okay? Which matter are you here for?
Same for Devin.
Okay, he's being brought up. Let's see, is Mr. Wakefield here? He is. Okay, on the record in the matter of the people of the state of Michigan versus Laverne Wakefield, file number 21-02752, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
I'm just really not following what's going on. All these people requested court-appointed counsel. I need an appearance on all of the files.
I talked to somebody on the phone, I think it was just, yeah,
Can I have your appearance, please?
Assistant Public Defender John Lee, appearing on behalf of Laverne Wakefield.
Today was the date that was set for a hearing for probation violations that he was arraigned on. How are we proceeding?
Mr. Wakefield would like to plead guilty to violation, Your Honor.
That's correct, sir.
yes,
You
ma'am.
want to waive your hearing?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. The last violation I have here. Was that you failed to make payments on your fines and costs. Last payment was made on October 2nd, and that you still had a balance of $395, and that you per Cordant Health Solutions on November 22nd was positive for cocaine with a result of 69,930 nanograms per milliliter, and positive for cocaine again on December 1st with a result of 54,670 nanograms per milliliter. So you have the right to have a contested hearing. You have the right to be represented by counsel at that hearing. If you're found to be in violation, or if you plead guilty to the violations, you understand that you could have repercussions that include a jail time or an extension of your probation status.
Yes, Your Honor.
And you want to waive your right in order to enter a guilty plea to that violation?
Yes, ma'am.
Anybody threatening you to get you to do that?
No,
Any promises being made to you in order for you to plead guilty to these violations?
no, Your Honor.
As to the violation that you failed to make payments for your fines and costs, with the last payment being made of October 2nd. Your balance being $395. How do you plead?
I plead guilty.
As to the violation that per Cordant Health Solutions on November 22nd, that you tested positive for cocaine, and that you tested positive for cocaine on December 1st. How do you plead?
I plead guilty, Your Honor.
Okay, have a factual basis.
Thank you, Your Honor. Mr. Wakefield, is it true that you were found guilty or pled guilty in case number 21-02752, the original charge being child abuse fourth degree?
Yeah.
And is it also true that as a result of that plea, you were sentenced to a term of probation?
That's correct.
As part of that probation, you were ordered to make payment for fines and costs, correct?
Yes,
And the last payment you made was October 2nd, 2023. There is still a remaining balance of $395, correct?
yes,
And then you also had a positive cocaine test on 11/22 of 2023, correct?
Mhm.
And that's in violation of an order that you had in probation to abstain from any controlled substances, correct?
That is correct.
No further questions, Your Honor.
Any questions from the people?
Did Mr. Wakefield, did you also test positive for cocaine on December 1st of 2023?
Yes,
No further questions.
And you knew it was cocaine that you were taking at the
yes,
time?
yes, indeed.
Okay, you knew that was in violation of your probation status?
Yes.
Okay, I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. The recommendation from probation is to terminate probation and highly suggested to impose jail time. It says defendant continues to test positive for controlled substances, and he has a completed IOB, currently enrolled in MMRS for relapse prevention from last violation. You can address the court.
Thank you, Your Honor. I would note that Mr. Wakefield came here today prepared to accept responsibility for his actions. He doesn't equivocate at all and readily admits that he did violate his probation. He had expressed remorse to me when I spoke with him on the phone about it, and said that he wants to be in compliance because he does want to complete programming and resolve any remaining drug issues that he might have. So he comes here sincerely and humbly and asks for the court to give him a chance to get back into programming and successfully complete his probation.
Oh, Mr. Wakefield, did you want to say anything for yourself?
Well, Your Honor, just if you do, for my probation sends me on the original charge, I'd like for you to take into consideration. I do have a full-time job. I do take care of my wife and kids at home. However, I do have a substance abuse issue, and I am taking care of it. I'm going to therapy through MMRS. However, I'm thinking, because I still use time to time, and perhaps maybe rehab or something would be more ideal.
It's interesting that the appellate defender is advocating for you to have a chance to show the court, but it can't, to say the least, the court's giving you more than a chance, don't you think? You, even before we got to the stage of probation, I had you on bond. Do you know how many times you violated bond by using substances?
I do.
Let's see, 1, 2, 3, 4, 5. Even before I took a plea from you, you had over 5 violations, all for substance abuse. Oh, wait, 6, 7, 8, 9. You had 9 violations before we took your plea. And then since you've been on probation, you've had more than 11 violations, every last one of them involving the use of controlled substance. I've ordered you to complete treatment for controlled substance. I've ordered you to complete IOP. I've ordered you to complete or enroll in MMRS. I've extended your probation. I've given you so many chances to take the reins of direction as it relates to your recovery and your treatment. It was your responsibility to take into consideration then that you are employed. That I took that into consideration. It was your responsibility to take into consideration that your actions could put you in a position that would take you away from your family and your ability to provide for your family. But more importantly, the substances that you continuously ingest and engage in the unlawful use of could put you in a grave, okay? You could no longer be on the earth because you're poisoning your body. And I can't make you do right. That there's nothing I can do. If I don't even have the qualifications to make you do right. You're the only person who can make a decision that, you know what, I'm going to stop this cycle of abuse of my body so that I can be here, I can be healthy, I can show up and do what I need to do for my family. And I've given you more than ample opportunity to do that. You have continuously failed both probation and bond. And I'm left with no other choice but to remand you to the custody of the Ingham County Jail. I'm going to sentence you to 180 days in the Ingham County Jail. You'll be no earned early release, no GPS tether. You only be released if you can be admitted to inpatient services. You would be released directly to inpatient treatment. Do you understand that?
Yes.
And that's up to their availability. You can be screened once you're at the Ingham County Jail for that treatment, and then you'll get that treatment. You don't need to worry about not having that support, because we've tried to give you the opportunity to self-support and self-direct that treatment through a course of supervision of the court. We've not been able to do that. I can no longer continue to babysit you in 2024, okay? Good luck to you, sir. Representative Julie. You? Oh, okay. Did you need to speak to him?
No, we're ready to go.
Okay, on the record in the matter of the people of the state of Michigan versus Devin James Lee, file number 21-03019, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
And Jacob Rowley on behalf of Mr. Lee.
Okay, how are you, Mr. Lee?
Doing well.
Glad to hear that.
Yeah, yeah.
I'm glad to hear that too. You told me that the last time I saw you though, and I don't believe that you were being as honest as you needed to be. I took action and remanded you in custody due to my concerns about the nature of the violations and the amount of violations that I had, and to corroborate, I would say, my concern, I received another violation that I need to arraign you on. It says here, requesting summons for a probation violation, which I'm going to sign and date for today. I'm just seeing it. It says here that you allegedly violated the terms of your probation by committing the following technical probation violations. It says per JSG Scram Tether, confirmed alcohol consumption event began at 12:40 p.m. on January 16th, 2024, and ended on or at 8:21 p.m. on January 16th, 2024, with a peak TAC of 0.06. It says defendant was in court on that date, January 16th, 2024, in the afternoon for arraignment for a violation, which would indicate that you were under the influence at the time you were here for your arraignment, if true. And so you have the right to have a contested hearing on those violations. We do have the representative here from JSG present via Zoom, prepared to proceed with any hearings on these violations. You have the right to be represented by counsel, and you are represented by the public defender's office for today's purpose. How did he want to proceed on this violation?
Accountability is important.
Your Honor, my client will admit to that violation, plead guilty.
Okay, what about the other remaining violations?
Actually, he will plead guilty to the remainder of the violations.
That's correct. You want to plead guilty to all of the violations?
I do.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, and you understand that the penalty for violation, if you plead guilty or if you are confirmed to be guilty by hearing, could be that your probation status can be revoked and you can be sentenced to a term of jail time.
Yes, ma'am.
You understand that I could decide that I'm going to extend your probation and I could impose increased sanction oversight. Not really sure what else I could do, considering you're already on scram tether, but it's possible I could add sober link or some other things. You understand that?
Yes, ma'am.
Okay, and you want to waive your right to a contested hearing today?
I do, ma'am.
Is anybody threatening you to get you to do that?
No, ma'am.
Has any promises been made to you in exchange for a guilty plea?
No, ma'am.
Add to the violation that per JSG Scram Tether confirmed consumption of alcohol event on 4:35 PM on December 28th, 2023, and ended at 6:55 AM on December 29th, 2023, with a peak TAC of 0.2555. How do you plead? That's a violation that per JSG Scram Tether, there was a confirmed consumption of alcohol event that began at 5:10 PM on January 1st, 2024, and ended at 3:53 AM on January 2nd, 2024, with a peak TAC of 0.232. How do you plead?
Yes, Your Honor.
As to the violation that per JSG Scram Tether, there was a confirmed consumption of alcohol event that began at 4:37 PM on January 2nd, 2024, and ended at 12:20 AM on January 3rd, 2024, with a peak TAC of 0.166. How do you plead?
Yes, Your Honor.
As to the violation that alleges that you were positive for controlled substance and alcohol per EverHealth on December 7th, 2023, that you tested positive, results yielding greater than 25,000 nanogram per milliliter ETG and 6,985.49 on December 7th, 2023, and that you tested positive, yielding results greater than 25,000 nanogram per milliliter ETG, and that you had amphetamine 4733.53 nanogram per milliliter, and methamphetamine 10,991.81 nanogram per milliliter. How do you plead?
Yes, Your Honor.
And then as to the alleged violation that per JSG Scram Tether, there was a confirmed consumption of alcohol event that began at 11:30 AM on January 5th, 2024, and ended at 5:08 PM on January 5th. Second event then beginning at 11:30 AM on January 5th and ending at 5:08 PM on January 5th. Second event again began at 11:06 AM on January 6th, 2024, and ended at 2:57 AM on January 7th, 2024, with a peak TAC of 0.240 on January 6th. How do you plead?
Yes, Your Honor.
And then lastly, as to the violation you were arraigned on today of a JSG confirmation of alcohol event beginning 12:40 PM, January 16, 2024, and ending at 8:21 PM, January 26, with a peak TAC of 0.06. Defendant being in court on January 16, 2024, for an arraignment of violations. How do you plead?
I plead guilty, Your Honor.
Factual basis on each, please.
I do want to ask though, I think you might have missed one, the January 8th. event that you mentioned.
Let's see. Let's see, I think I did read that one. The event actually didn't occur on January 8th. That's the date that they requested violations, but I have.
I see another one, the event beginning 12:08 PM on January 8th, ending 1:28 AM. January 9th.
Let's see. Maybe I don't have that one in my file. Oh, no, I do see that here. It's just not tagged. That's why. Okay, thank you. As to the violation alleging that per JSG Scranton had their confirmed consumption of alcohol event beginning at 12:08 PM on January 8th, 2024, ending at 1:28 AM on January 9th with a peak TAC of 0.234. How do you plead?
Guilty, Your Honor.
Okay. Actual basis now.
Your Honor, Mr. Lee, is it true that you were sentenced to a term of probation by this court?
It was.
And that one term of this probation was that you were not to consume alcohol or any controlled substances without valid prescription. January 16th, is it true that on or about January 16th, you consumed some amount of alcohol when this was detected by your scram tech?
Yes, sir, it was.
True that on or about December 28th of 2023, you consumed an amount of alcohol that was detected by your scram tech?
Yes, sir.
It's true that on January 1st of 2024, you consumed alcohol and this was detected. January 2nd, you consumed alcohol. Going back to December 7th of 2023, is it true that you consumed alcohol and methamphetamine, and that both of these substances were detected by a test at Amber House? Is it true that on January 5th of this year, as well as January 6th, you consumed alcohol and that this was detected by your scram?
Yes, sir.
And finally, is it true that on January 8th of this year, you consumed alcohol and that this was detected by your tech? I believe that's a factual basis.
Any questions from the prosecution?
No, Your Honor, thank you.
Satisfied with the factual basis, I'll accept your plea and I find your pleading made freely, voluntarily, and intelligently. It says here, recommendation of your probation officer is to terminate probation, impose a term of jail time to be released to residential treatment. Let's see, it says you have a pending OWI charge committed while on probation that's set for show cause hearing. Additionally, it says defendant was intoxicated during the probation violation arraignment on January 16, 2024. Again, that event beginning 12:40, 1:16, less than an hour before you were supposed to be in court, ending at 8:21 PM. You can address the court, Mr. Staples.
Thank you. Your Honor, I do want to note that Mr. Lee did have a court date regarding that pending OWI case in East Lansing. I believe the plan now is for him to be screened for sobriety court in that jurisdiction. So that's something that he certainly is wanting to take advantage of, if they will accept him. I don't know why they wouldn't, but he had to go through the screening process, of course. I think Mr. Lee certainly admits that he had a significant relapse in recent months, and that this is something that frankly he needs more intervention, if that's the right word, to help him deal with this, to help him remain sober. I hope that the sobriety court can achieve that. I hope frankly that he'll be given a chance to complete his probation in this court with the goal of eventually entering into the sobriety court in East Lansing and completing their I know it's more intensive and hands-on course of treatment. I know that Mr. Lee understands that he cannot continue to bounce back and forth with these relapses and new cases and violations. He has a family to take care of, and he doesn't want to be in jail anymore.
Did Mr. Lee want to say anything on his own behalf?
Yes, ma'am. I got a long history, as you can tell. I've been to prison a few times. I've struggled with substance abuse, my entire teenage years. I've gotten away from all the heroin, the substances, and drinking isn't any better. And I realized that I kind of used it as a vice, through the holidays and a lot of personal things going on with my family. And I did have a significant relapse, but I want to take care of it. I just found out wife is pregnant and it's my first kid. It's kind of a perspective change for me. So from the 9th until the 16th, I didn't drink, but that day I did because I was anxious of going to jail and leaving my wife, and I didn't want to do that. But I did drink, and I just showed up, and I stayed here, and I knew I was going to jail. Like I said, I've come a long way with my substance abuse and my personal addiction. Drinking isn't even something I enjoy, more or less a mental health thing for me. And I don't, like I said before, I don't want to run from it. I want to take care of it. I expect a kid, and I couldn't be happier for that. And I would appreciate being able to be here for my wife. She's struggling without her husband. And I know that jail is not going to do it because I've spent years in prison, years and years in jail. This little baby kind of threw me in a loop, and after that, I kind of have a little time to look at things differently. Something that I've never really experienced.
That's interesting. You told me that on the
Oh,
16th while you were under the influence, and you knew you had a JSG tether that was going to detect the alcohol.
Yes, ma'am.
So you looked me in the face and told me a bold-faced lie about you being a changed person and how you had a rough time over the holidays, but that, once you found out about the pregnancy, that you turned over a new leaf. But in fact, on your way to court, you chugged alcohol.
I had 2 shooters of alcohol because I was so anxious of going to jail. My wife was so nervous for me, and I honestly, I didn't want to come. I didn't want to be here because that's my forte is running away from these things because I'm scared. And
I recognize that you in your mind believe that you had a reason why you did that. But what I'm trying to get you to understand is how nonsensical that reason actually was. You're on probation for operating while impaired, a alcohol related or substance abuse related charge. This is not your first time that you've had such a conviction. Your criminal history reflects to me that you had one in 2011.
OWI.
That's what it says. And now you have a new case pending. Not only are you here for, and this is a situation where you've had more than these violations that we just addressed today. You've had 8 technical, 2 non-technical. I've tried extending your probation. I've tried implementing more oversight with the tether that you were on to try to give you more structure. And again, you said yourself, you've been to jail before. And so if that was the case, then what is it going to take for you to garner the tools from those lessons so that you can do better for yourself? Because if you can't do better for yourself, you sure enough can't help your wife or any child. Your wife's not struggling because you're in jail. She was struggling because she was living with an alcoholic. That's why she's struggling. Anybody walking around with this kind of blood alcohol content from day to day has a death sentence on them. You're just waiting for your body to give out on you. There's nothing healthy about that. And then using the excuse that I was nervous or that it was a mental health thing is not helpful either, because we knew that you had an underlying mental health concern. I ordered you to continue in a course of treatment for that. And that course of treatment didn't involve you substituting your treatment course or your medication for the use of alcohol. There's nothing that goes hand in hand with alcohol use and mental health. It's a recipe for disaster. And if you don't know that by now, especially with your criminal history, I don't know what other circumstances could present themselves to make you aware of that, except for life in prison because you committed something that was, so egregious that that's what you're facing, or you killed yourself. I don't know what else could put that through your head. And having a child in and of itself is not going to make you change your mind. You have to decide, I'm not doing this anymore. I'm not putting myself through this. Having a child, I'm sure, could motivate you. It could cause you to have something to look forward to and understand, I got greater responsibility than just myself. But at the end of the day, the child can't make you do it. You have to do it. You're the adult. Okay, you are the person who's supposed to drive and motivate your life. And you were the one who made the decision to consume the alcohol all of those times and to consume it on your way to court. You don't think that Mr. Staples gets nervous on his way to court? You don't think Mr. Lee gets nervous on his way to court? Do you think Ms. Petrosky gets nervous on her way? Do you think that it's okay for them to chug alcohol on their way? No, you still have to be responsible. That's not how we deal with nerves and anxiety as an adult. You're not a child, okay? And so I don't have a choice. I've done all the things that I could to try to get you to redirect your path. And then you picked up a new case, and it's not meaningful. And not even just that, it's of grave concern. And I said this before, I think you're gonna kill yourself if I let you out. You're gonna drink yourself to death. And there's nothing that you can say that would make me feel any other way, because I'm sitting here with a case that has over 8 violations in it, and 7 of them in the same week almost. And then the last one being when you were before the court and you looked me in the face and you told me how you had changed and turned over a new leaf. When you knew you had just drank, and you could have just said that. Actually, Your Honor, I've been struggling, and I be honest, I drank today. I'm struggling. I need some addition. And you were not candid then. And I don't believe that you have what it takes to do it on your own. So because of that, I am going to remand you to the custody of Ingham County Jail for 90 days, Ingham County Jail, and you will be screened and released to residential treatment only. And then you can maybe get the tools that you need so that you can take care of yourself, make better decisions, and then hopefully be a better father. But I don't foresee you making those choices on your own, because we've given you ample opportunity to do that. And you've been on probation before me for more time than necessary. And so with that being said, that's the order of the court. You'll be screened while you're in the custody of the jail. We'll get this scram tether removed from you if it has not already been removed, and then you can be released only and directly into residential inpatient treatment. Any additional matters for today's record?
Nothing from the people, Your Honor.
No, Your Honor.
Thank you.
Thank you. Mr. Hayes. And let's see, Mr. Quintana is ready.
Yes.
Back on the record in the matter of the people of the state of Michigan versus Rodrigo Ponce Quintana, file number 23-01122. And appearance, please.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Rodrigo Quintana.
Okay, Mr. Rodrigo Quintana, again, there was one remaining violation. That's violation number 3, that you failed to appear for monthly probation meetings back on October 12th, 2023 and November 9th, 2023 via Zoom, and that you had absconded from probation as of November 28th, 2023. And you've met with counsel. Counsel, how does he want to proceed?
Your Honor, Mr. Quintana is going to plead guilty to that allegation.
That's correct, Mr. Quintana. Please raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. Thank you. You can put your hand down. Okay, and so you understand your right to have a contested hearing as it relates to these violations. Okay, and you want to waive your contested hearing so you can plead guilty to violation? Anybody threatening you to get you to do that? Okay, any promises being made to you if you plead guilty to the violation? As to the violation that you failed to appear for monthly probation meetings on October 12th and November 9th, 2023 via Zoom, how do you plead? Factual basis.
Thank you. Mr. Quintana, on or about June 12th of 2023, did you plead guilty in case number 23-01122? Domestic violence?
I did.
And on or about August 14th of 2023, you were sentenced to a term of probation in regards to that guilty plea, correct?
Yes, sir.
And as part of that probation, you were ordered to meet monthly with your probation officer via Zoom, correct? Yes, sir. And on August 12th, 2023 and November 9th, 2023, you failed to meet with your probation officer via Zoom, correct?
Yes.
No further questions.
Any questions for you, Mr. Petrowski?
No, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea if find your plea made for you voluntarily and intelligently. The recommendation of probation is to continue your probation, hold a weekend in jail in abeyance pending any further violations. It says your overall attitude has been fair and your progress has been fair to poor, and your acceptance of responsibility being fair to poor. It does say that you have enrolled in the domestic violence program online. You also enrolled at and have been attending Kristen Ray parenting class. And there was a new referral given to you for the outpatient at Kristen Ray. Additionally, has made a payment towards fines and costs. You can address the court.
Oh, thank you, Your Honor. Mr. Quintana reports that at the time that he was supposed to meet with the probation officer, he was working in Sault Ste. Marie. Reports that his call service was spotty and emails that he thought had gone through. Point being, he's been working hard. He has signed up for all his classes and all the requirements, and he wants to successfully complete probation. Your Honor, he understands that this was not the right way to go about things, and that he has a responsibility, regardless of what his work schedule is or where it takes him. That being said, he does wish to be reinstated in probation and intending to comply with all probation orders.
What kind of work are you doing up in Sault Ste. Marie?
Road construction, Your Honor.
Okay, right. Been up in that area more than a number of times. I can recognize where your service would be spotty. But you still have a responsibility, don't you? And I'm sure that you get in contact with whoever you deem important enough to get in contact, regardless of spotty contact, don't you?
At the time, I didn't even contact anyone, said I haven't anybody to contact. Your Honor, but
Well, you did have somebody to
yeah,
contact.
I mean,
You were supposed to contact Miss Bayless.
Yes, I understand that, Your Honor.
Right now until August 2024, she's like one of your best friends. She's the person you're gonna talk to at minimum on a monthly basis, whether you like it or not. And so whether your service is spotty or not, I mean, it's a privilege to be able to appear via Zoom. We could require you to appear in person, meaning you got to drive all the way from wherever you're working and come in person. So take advantage of these privileges and use it to your benefit. You don't have good service. I'm sure you had to sleep somewhere while you was up there. I'm sure that they had Wi-Fi and you could get on Wi-Fi and confirm your email went through. I'm sorry I missed my date. Can we reschedule? I'm working up in Sault Ste. Marie. Looks like you've gotten back on track with all of your other obligations. You've been making payments, is that correct?
Yes, Your Honor.
When are you gonna make your next payment?
I should be making it here next Wednesday.
And then you're participating in the programming as ordered. You're working. I'm gonna continue your probation. And it says you're scheduled to get off in August, so we'll continue your probation at this time. You'll report at your report date, okay?
Yes, Your Honor.
Good luck to you.
Thank you, Your Honor.
Ma'am, are you waiting for a case?
Oh, no, I'm an intern for Temporary Diabetes Center.
Oh, okay, sounds good. Okay, unfortunately, I think the next 3 cases I have are private. I don't know if you want to go observe across the hall.
Oh, no, I'm actually going to tune in with him on a meeting that.
Okay,
after me
wonderful.
Anyway, so.
Well, thank you for stopping in.
Thank you. Have a good
You too. We can have, let me make sure.